We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
Welcome back to our special Talking Liberty segment. We're looking into the big case this week that impacts your liberty and your freedoms. And as ever, we have constitutional attorney and host of the most excellent Uprising podcast, Mr. Scott DeCasenza, Esquire, to help analyze the legal morass. Thanks for being here, Scott.
Always a pleasure, Mark.
So, Scott, first story I want to talk about. New York Governor Kathy Hochul. She wants to silence, and I quote that there, silence constitutionally protected speech. What are the details here?
Well, she's used the opportunity of the Buffalo supermarket massacre to advocate for restricting people's constitutionally protected rights. Mark, it's a real profile and courage for the First Amendment. She stands second to none in protecting free speech rights, except for hate speech and other unfortunate expressions of speech, which she doesn't support. You know, it's anytime somebody says
these are her principles. If you don't like them, she has others.
Anytime somebody says I support the First Amendment, but or something, but you know that they don't support them, because that's what the but means, is that they actually don't. What support for the free speech means is, and really so eloquently presented by Elon Musk recently, it's just, you know, somebody that you don't like can say something that you don't like, and that's protected. That's sort of a good modern colloquial way to refer to it. But what Hochul said was, I'll protect the First Amendment any day of the week, but you don't protect hate speech. You don't protect incendiary speech. You're not allowed to scream fire in a crowded theater. There are limitations on speech. Well, to the last point, which is popularly misunderstood, that's a double lie. And what I mean by a double lie is, firstly, she misstates what that rule said, and that rule is no longer in place. What that rule said, firstly, was that it was impermissible to falsely scream fire in a crowded theater, which is an important difference. And also, that's not the law. What the law says is that for speech to be made illegal or criminal, it has to be both call to action for immediate violence and also likely to produce that action or reaction. So that's the current legal standard, the Brandenburg test. And this meets none of it. And it's such a disappointment to see this from New York's governor.
So the governor's actually made some moves on this, Scott. What specifically is she doing?
A bunch of new gun control proposals she's made, and including changes to the red flag laws, which now require reporting, where before they were optional, and a massive surveillance infrastructure to review social media posts, and also punish, somehow left unspecified, the social media outlets that allow live streaming, for instance. It's an across-the-board Orwellian move against free speech rights in New York, Mark.
I just don't see how this can work, because people are making these live streams on pretty much every platform. Does a live stream capability, but they're not doing them from New York more often than not.
That's not a problem for Kathy Hochul to solve, Mark. That's a problem for Mark Zuckerberg and some nerd in the Silicon Valley to solve. Kathy Hochul's only job is to keep the people of New York safe, not to make sure that social media platforms are able to function effectively.
I think the most troubling thing about this is that Attorney General Letitia James is also full steam ahead on this idea.
Well, let's recall the important part about her is that she's a politician more so than a law enforcement officer. She proved that with the NRA fiasco, and she's doing more to prove it here now.
So quick roundup on this final one here. Is this going to be challenged, and will it be a successful challenge?
The more any formal prosecution or examination of social media, once that's in place, then the challenge will come, and fingers crossed it'll be successful.
Okay, now let's move on to one that I found really fun, because California's had some ups and downs recently in the legal world. Firstly, there was the ruling that it was unconstitutional. Was it magazine bans?
Yes.
And then more recently, this week, in fact, California law requiring that women and minorities appear in corporate boards to specific numbers. That was struck down as well. What are the details here?
So I was just looking to to see the name of the judge who it's Judge Duffy Lewis of I think the Superior Court of California has responded to a challenge that California companies or companies that are headquartered in California have a certain minimum female participation rate on their board, depending on the number of board members in total. And what the judge said was that this clearly is unconstitutional, just sex-based discrimination that's not allowed. How our constitutional framework currently exists with respect to sex-based discrimination is that it has passed by an intermediate standard, and basically it has to be sort of an important goal that's not easy to meet by other means. And one of those goals can be remedying past discrimination, and that would be allowable. And the judge found that this bill was not at all to remedy any past discrimination or any of the other permissible reasons to discriminate on the basis of sex, but instead was just to try to generate parity. They wanted, the pushers of it wanted 50% or better, presumably participation on boards by females, and you're not allowed to use the law and discriminate on sex to achieve that.
Now, I want to dig into this a little bit because I find it fascinating that this even made it far enough that would need to be challenged as a law in court. So what if there was a company set up by women for women? Would they have to, and the board got to a certain number of participants, would they then have to take on a man?
No, Mark, that would be, you're describing an example of what in their mind would be an enlightened and forward-thinking company to have so many female voices on. Diversity only counts for the favored groups. So if you're, for instance, Caucasian or male, you're not included in the world of diversity. Diversity is generally female and generally black or brown, and then also with respect to sexual orientation, certainly trans status or gender queer in some form, blue hair, these sorts of things are what counts, not the other.
We'll be having all the Harvard graduates collect their certificates, pick up a bottle of dye, and then go and get their hair done.
Yeah. Now, let me just add, though, that this wasn't a law, based on your first comment that you were surprised that it got this far anyway in the courts. And that would be a surprise to the people who put it into law as well. Just to be clear, what we now know, Mark, is that the Attorney General himself, Padilla, and this was when Jerry Brown was governor of California when the law was passed before Newsom came in. The Attorney General himself sent a note to the governor and said, this is going to be unconstitutional. If this gets challenged in court, we're not going to be able to enforce it. It's just for the lulz, it's just for dunking on these corporate boards and making them the politicians who pass these laws, sort of elevate them in the minds of the progressives who demand it, even though, Mark, it's clearly forbidden by the Constitution.
Well, let's track this a little bit further. So this came in under Jerry Brown and was a law in the state of California.
Yes.
So companies would have had to react to this, otherwise be in violation of the law as it stood then, and therefore have spent time, effort, money, and resources in either attempting to or successfully complying with that law.
Yes, that's exactly right.
And they have no recourse.
Well, they could move out of California.
But they have no recourse for the time and investment and effort that they've put in to fulfill something that's unconstitutional.
That's how our system is set up. When the government wrongs you, very often you have little to no recourse.
All right. Well, let's go to one where the government has had a bit of a slap in the face. Just for our final story, Scott.
By the way, Mark, let me just add, that's why you can't get a moving truck to take you out of California fast enough, right?
Absolutely.
Yeah.
Now, Ted Cruz, Senator Ted Cruz out of Texas, has had a bit of a win in the Supreme Court this week. Quick rundown for us.
He did, and kudos to Mr. Cruz, because he basically saw a portion of the law that he thought was unconstitutional, and then he basically just devised a case to get to the Supreme Court, and he won. And it's just, take away your personal feelings or political feelings about Mr. Cruz, just in terms of a legal, calling your shot and then making it is pretty interesting from this lawyer. This concerned a a Federal Election Commission restriction on campaigns being able to pay back loans that the candidates themselves made to the campaigns. And it was a anti-bribery statute, which is that's the stated goal of the statute. It seemed like it was, it wasn't like some anti-Republican thing or some other, mechanism by which the FEC discriminated against one side or the other, except for that it discriminated against particularly wealthy candidates who have the dough to loan their campaigns a good amount of cash. So now that restriction is over, and Cruz both won on the law and on the procedural grounds. The FEC had argued that he didn't have the legal capacity to stand and challenge the law. Many of these cases at the Supreme Court are, we argue about standing and then the actual underlying law itself. And he won on both points. So he's sitting tall this week for sure.
Yeah, Ted Cruz was actually a clerk in the Supreme Court in his younger days, I believe. So that if somebody knows how the system works, it should be him.
I think he was a Rehnquist judge.
He was.
Yeah.
All right, Scott DeCosenza, thank you ever so much for being here. Much appreciated.
Thank you, Mark.
And that's about it for this week's edition of Liberty Nation Radio here on the Radio American Network. My sincere thanks go out to our guests, Tim Donner, Dave Patterson, Sarah Cowgill, and Scott Cosenza. And of course to you, the listeners. Thank you for being here with us. My parting shot for this episode, I'd like to borrow from Thomas Jefferson, who said, quote, "I predict future happiness for Americans if they can prevent the government from wasting the labors of the people under the pretense of taking care of them," end quote. When the government treats us as children and sees that nannyism is a surefire vote winner, something has gone deeply and terribly wrong. Freedom comes from being able to use your labors to continue your heart's pursuit of happiness. And yet the world leaders see fit to spend our tax dollars elsewhere on pet projects and ideologies, and then castigate us for not wanting to treat said leaders as our true benefactors. This is not a model for success, nor is it one that can in any way lead to more happiness nor freedom. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
We're doing it for real, really real. Liberty Nation.
And Jeff Charles, contributor for LibertyNation.com.
I think we're starting to make an impact. Liberty style, fighting for freedom.
The tracking poll sponsored by Liberty Nation for Thursday.
Mentioned by Dan Bongino, Rasmussen, Jordan Peterson, and
I
others.
can do it again if you want me to.
Cited in Mark Levin's American Marxism.
I think we're starting to make a really big impact. Get noticed. We're doing it. Rock on. I'm gone.